Good morning, everyone. Welcome to today's hearing. Today we begin Module 2 of this phase of the inquiry, in which we're going to investigate the way in which products intended for use in the construction industry are manufactured, tested and sold, and in particular the way in which the materials that were used on the cladding of Grenfell Tower were presented to the market. We shall begin by listening to core participants' opening statements. But before we do that, I should like formally to welcome Mr. Ali Akbar to the panel. Mr. Akbar, who was recently appointed to the panel by the Prime Minister, is embarking on his role today. On behalf of Ms. Istefan and myself, I should like to welcome Mr. Akbar as a fellow member of the panel. We look forward to working with him and benefiting from his experience, and we hope that he will find his new role interesting and stimulating, as we both have. Unfortunately, Mr. Akbar is unable to be here in person this morning because he and his family have recently been isolating due to coronavirus. But he's participating in the proceedings remotely, and we are in constant communication with him. So with that introduction, I'm going to invite Mr. Millett to make a brief opening statement on behalf of the inquiry. Yes, Mr. Millett.
Thank you, Mr. Chairman. Mr. Chairman, members of the panel, we now open Module 2 of this phase of the inquiry, and I would like to begin by adding my own warm welcome and that of my Counsel team to Mr. Ali Akbar, who joins the panel from today. Module 2 is all about the principal materials used in the cladding system installed at Grenfell Tower as part of the refurbishment in the years 2012 to 2016. Those materials are, first, the Rainabond PE55 cladding or rain screen panels manufactured and sold by Arconic. Second, the RS5000 insulation boards manufactured and sold by Celotex. Third, the Kingspan Cooltherm K15 insulation boards manufactured and sold by Kingspan. Fourth, the window infill panels made by Aluglaze. And fifth, the Lamatherm cavity barriers manufactured and sold by Siderise. The specific issues that we will be investigating are those contained in Issue 4A of the inquiry's updated list of issues, which can be found on the website, but they are as follows. And their title is Testing, Certification and Classification Exterior Wall Materials. A, what testing and or certification and or classification had occurred in respect of the exterior wall materials at Grenfell Tower, including the cladding and insulation. B, was any such testing and or certification and or classification adequate and appropriate? C, is the testing, certification and classification regime for external wall materials fit for purpose? We will also be examining at issues 4D to H in the updated list of issues, so far as concerns the particular component elements of the cladding system installed at Grenfell Tower, the following. D, was the exterior of the building, including the cladding, insulation, fixings and windows, compliant with relevant building regulations, fire regulations, other legislation, British standards, including testing requirements, guidance and industry practice? E, to the extent that it was compliant with such regulations, legislation, British standards, guidance, etc., were any of those inadequate, and if so, in what respect, so far as relevant to the nature and immediate causes of the fire and its spread? F, if not compliant in any respect, what elements or aspects of the exterior of the building at the time of the fire failed to comply with what elements or aspects of what regulations, legislation, British standards, guidance, industry practice, and in each case to what extent? G, who was responsible for such failures? And H, what advice or information was available and what assessments were made about the components that comprise the exterior of the building, their fire safety, fire resistance and compliance with safety standards, including information or advice from manufacturers of relevant components. Turning to the topics for Module 2, in general terms, in the first part of Module 2, we will be hearing from witnesses for or from each of the manufacturers of the principal materials. We will be investigating what they did in order to subject those products to fire safety tests, how those tests were set up and pursuant to what requirements or guidance, how the results of those tests were recorded and archived, and who had access to them, what information was provided by manufacturers to certifying bodies, and how certificates came to be issued in the form that they were, how the marketing and technical literature published to the UK construction market by each manufacturer for each such product came to be composed, and whether that literature presented its fire classification and fire performance in a fair and transparent manner, and what each manufacturer knew about the specific application of its product for use in the cladding system proposed for installation at Grenfell Tower, and their role in selling and providing such products to Studio E, Ryden and Harley for use in that system. We propose to take the evidence starting with witnesses from Celotex, and then Kingspan, and then Aluglaze, and then Siderise, and then finally Arconic. We're likely to take the evidence of Mr. Stern of SIG, SIG, in either December 2020 or January 2021. Later in Module 2, we will hear witnesses from the testing house, the BRE, in respect of the testing to British Standard 8414 of the systems incorporating the Celotex and Kingspan insulation products and the classification of those systems. We will also be hearing from the main certification bodies, namely the British Board of Agrément, or BBA, in respect of Arconic's Rainobond PE55 panels, the one certificate that predated the fire, issued on the 14th of January 2008, and Kingspan's Cooltherm K15 insulation products, namely 5 certificates running between October 2008 and November 2015. We will also hear from Herefordshire Building Control, who, under the auspices of the Local Authority Building Control, LABC, provided system approval and registered details certificates for Kingspan's K15 from May 2009 onwards. We will also be hearing evidence from LABC in Module 6, when there will be further and broader examination of the testing and certification regime in general, and construction products more generally in turn. In Module 2, we will be examining with them the role they played in the tests, how they interpolated the test results, the extent of their audit or monitoring of the manufacturers, and how each of the key certificates involved in this inquiry came to be composed and worded as they were. Turning then to the outline programme, by way of an outline programme for Module 2, we will have the oral opening statements from certain of the core participants today, and again on Monday the 9th of November. Next Tuesday, the 10th of November, we will have the benefit of a presentation to be given by Dr. Barbara Lane on the subject of fire testing and classification. In that presentation, she will explain the relevant fire classifications and the applicable testing regimes and methodologies, including those relating to National Class 0 and limited combustibility. On Wednesday, the 11th of November, we will have the first of our factual witnesses in Module 2, namely Jonathan Room of Celotex. The factual evidence for Module 2 will then run until the 1st of February 2021. Hearings will then cease for the festive period from the evening of Thursday the 17th of December and will resume again on Monday the 11th of January 2021 and will then run till the 1st of February 2021, as I've said. There will be no expert evidence at the end of Module 2. I want to say something about Arconic, if I may. As core participants know from the inquiry's letter of the 29th of September 2020, on the 25th of November 2019, the inquiry indicated that it would be calling oral evidence from 6 current or former employees of Arconic in Module 2, 3 of whom are resident in France, namely Claude Verla, Claude Schmidt and Gwenaël Derendinger, and 1 of whom is resident in Germany, namely Peter Fröhlich, and 2 residents who are resident in the United Kingdom, Deborah French and Vince Meekins. In January 2018, DLA Piper, Arconic's solicitors, wrote to the inquiry to raise the issue of Article 1 bis of French law number 68678 of the 26th of July 1968, as modified in 1980. It's more commonly referred to as the French Blocking Statute, or the FBS. This is a French law. It provides as follows: subject to international treaties or agreements and applicable laws and regulations, any individual is prohibited from requesting, seeking, or disclosing, in writing, orally, or in any other form, documents or information of an economic, commercial, industrial, financial, or technical nature with a view to establishing evidence in foreign judicial or administrative proceedings or in relation thereto. Article 3 of the French Blocking Statute imposes criminal sanctions for breach, being a maximum of 6 months imprisonment and/or a monetary fine. It extends both to natural and to legal persons. In January 2018, DLA Piper asserted that the French Blocking Statute precluded Arconic from disclosing a large number of relevant documents to the inquiry. They suggested that the inquiry seek to enter into an ad hoc agreement with the French government to provide an exception to the prohibitions imposed by the French Blocking Statute. While the inquiry reserved its position on the scope and the effect of the French Blocking Statute, and indeed continues to do so, in April 2018, we were able to confirm that DLA Piper could have a discussion with the competent French authorities with a view to facilitating a discussion between the inquiry and representatives of the French Ministry of Justice. DLA Piper also encouraged the inquiry to work with the Metropolitan Police Service to see if a mechanism could be found to obtain documentation via the concurrent criminal investigation and in a way which permitted it to be shared with the inquiry. In the light of that, the inquiry worked closely with the Metropolitan Police to gather witness statements and a significant volume of relevant documents, and it did so. In March 2020, so this year, DLA Piper said that it would revisit the issue of the applicability of the French Blocking Statute to the oral evidence of its witnesses in light of the decision by the Attorney General to extend the scope of her undertaking, which was originally provided in February 2020. In early June 2020, DLA Piper asserted that the oral evidence of the Arconic witnesses, who will be called to give evidence in Module 2, would engage the French Blocking Statute. DLA Piper suggested that the inquiry should seek the assistance of Her Majesty's government in reaching an agreement with the French government in order to overcome the constraints of the French Blocking Statute. As a consequence, the inquiry has sought assistance from the Foreign, Commonwealth and Development Office to explore the possibility for an agreement to be reached between Her Majesty's government and the French government that would permit Arconic witnesses to attend to give oral evidence to the inquiry without risk of prosecution under the French Blocking Statute. The inquiry has been in regular contact with the Foreign, Commonwealth and Development Office since June this year. Discussions continue. If the present position changes, then of course core participants will be informed at the earliest opportunity. Notices under Section 21 of the Inquiries Act 2005 have been served on Ms. French and Mr. Meekins within the United Kingdom, because they are within the United Kingdom. They have instructed their own solicitors, Wilmer Hale, who have told us that they have accepted service of the Section 21 notices on behalf of Ms. French and Mr. Meekins, and that those witnesses will attend to give evidence. They've also told us that Ms. French and Mr. Meekins have considered carefully the risk of prosecution under the French Blocking Statute. Having done so, are content to give evidence pursuant to the Section 21 notices without objection. They have reserved the right to revisit the application of the French Blocking Statute if and where circumstances warrant it, but as they've told us, for the avoidance of doubt, such circumstances are not at this stage foreseen. The same cannot be said for the Arconic witnesses who are in France and Germany, namely Mr. Werler, Mr. Schmidt, Mr. Endinger in France and Mr. Fröhlich in Germany. As to those individuals, we have taken independent leading and junior counsel's advice. As matters stand, we consider that there is no legal mechanism for effecting valid service of a Section 21 notice on a witness or potential witness for the inquiry outside the United Kingdom. and therefore, in consequence, there is no basis on which an English court could or would enforce such a notice. That is principally because the proceedings of the inquiry are not court proceedings to which international conventions on service of court documents apply. Unlike the two UK-based Arconic witnesses, those four non-UK Arconic witnesses are at the moment relying on their risk of prosecution under the French blocking statute as the reason for declining to come to the inquiry to give oral evidence. Neither Arconic nor any of those witnesses has provided any evidence that there is a real risk of prosecution under the French blocking statute if they did attempt to give oral evidence to the inquiry. On the contrary, there are very sound reasons for thinking that the risk of their prosecution by the French prosecutor is very low indeed. Not only has there been, to our knowledge, only one successful prosecution under the French blocking statute in the 51 years since that statute was enacted, but it is hard to think that the French prosecutor would wish to punish those individuals for giving evidence before a public inquiry in an erstwhile EU member state, looking into a notorious fire in which so many were killed. And that is all the more so where those witnesses have extremely pertinent evidence to give about the product principally implicated in the rapid and fatal spread of the fire. In the end, if Arconic and its witnesses seek to stand on their strict legal rights and refuse to come to give evidence, that is a matter for them. They may find that the BSRs, other core participants, and indeed the public generally, take a dim view of their conduct regardless of the legalities. Doubtless, Arconic will have considered the impact of its witnesses' refusal to give evidence on how they are viewed in the world beyond this inquiry, and in particular by the markets, both for their own products and the financial markets. Standing here, as I do, I can only urge Arconic and its witnesses to do the right thing and come and assist the inquiry. If they do not, then you are not completely powerless. The panel has at its disposal detailed documents from Arconic and witness statements from these witnesses. We will be showing the Arconic witnesses' statements and their documents to the public to tell the story of Arconic's role in selling their ACM PE panels to the UK construction industry, and particularly those involved in the Grenfell Tower refurbishment, as we have already heard from much of the evidence at Module 1. Those witnesses, by not attending to explain their words and deeds at the time, run the risk of adverse inference and criticism. And although due account must, of course, be taken of their reasons for not attending, the countervailing absence of evidence of a real risk of prosecution under the French blocking statute may also weigh in the balance. We provided a 6-day slot in the Module 2 timetable for these 4 non-UK witnesses. At present, that proposed slot runs from the 14th of January 2021, following the evidence of Ms. French and Mr. Meekins. If the 4 non-UK witnesses do not attend, then we will use some of those days to present the relevant evidence and the questions we would have asked them in what we intend to be a coherent way so that the public can understand what questions those witnesses would have had to answer. We may then be able to bring forward the remaining Module 2 witnesses, but that timetabling will of course be kept under close review. I should add that it is possible that we will need to recall during the course of Module 6 later in this inquiry some witnesses who would have attended or will have attended to give evidence in Module 2. I should also say something about Kingspan Cooltherm K15. As recently as the 29th of October, Kingspan's solicitors wrote to the inquiry attaching a letter directly from Kingspan to the BRE, saying that they were now withdrawing a number of their BS 8414 test reports and associated BR 135 reports. Kingspan's letter to the BRE said in terms that the very first test carried out on Cooltherm K15 in 2005 was not representative of the K15 product which had been sold by them from 2006 onwards. That is to say, the K15 tested in 2005 was essentially a different product to what was being sold after 2006. It was also confirmed that the K15 product used in 2 further BS 8414 tests in 2014 was not representative of the K15 product then on the market. The letter says that this was prompted by discoveries of irregularities relating to the testing systems, or the systems tested, which had in turn been prompted by requests from this inquiry. Now, this raises very serious questions about why Kingspan did not withdraw these reports at the earliest opportunity when it became aware of these issues and at the first sign of any material irregularity. The inquiry has been and had been actively pursuing this line of investigation with Kingspan for some 2 years. Therefore, questions as to why these reports continue to be relied upon, why they were not withdrawn earlier as a precautionary measure, and the timing of this letter are matters we will have to explore in the evidence. Clearly, however, this is a matter of significant public importance and will need to be investigated in this module and possibly at Module 6 as well. Members of the panel, that was all I was proposing to say by way of opening Module 2 to you. We will now turn to hear opening statements from the core participants, starting with Team 1 of the BSRs, represented by Ms. Stephanie Barwise, Queen's Counsel.
Yes, thank you very much, Mr. Millett. Now, before I invite Ms. Barwise to address us, can I just remind everyone that although we had been hoping to enable some of those representing core participants to address us in person, for reasons that I explained earlier in the week, the imposition of the lockdown makes it important for us to ensure that as few people as possible come through the building at any one time. And so we have asked all those concerned to make their opening statements to us remotely. So at this point, I'm going to invite Ms. Barwise to address us. Before I do that, can I just make sure I've got contact with Ms. Barwise? Good morning, Ms. Barwise.
Good morning, Mr. Chairman.
And you can see me and I can see you.
Indeed,
And
yes.
we can hear each other.
Good.
Good.
Yes.
Right, well then, over to you. Please make your opening statement, if you would. Thank you.
Thank you very much, sir. And good morning, Mrs. Stefan and Mr. Akbar. You have our written submissions. Our submissions today will fall into 4 parts. First, an overview of the crisis in industry so far as product testing and marketing is concerned, and the manifestation of that problem at Grenfell. Second, a brief review of the regulatory and testing regime. Third, analysis of the behaviour of the principal manufacturers in their testing of the Grenfell products. And finally, concluding remarks. Starting with the overview, it is all too clear that the manufacturers whose products were used at Grenfell were untroubled by the safety of their products, and some of them remain so, despite the disastrous fire. I will address their written submissions in due course, but it is of great concern that even now, Kingspan seeks to trivialise its wrongdoing, and despite compelling evidence to the contrary, Arconic does not even accept that it did anything wrong. Instead, Arconic continues to perversely assert that its product could have complied, even though that assertion is undermined by the test evidence relating to the Rainabon PE55 cladding panel, which the chairman has in any event found non-compliant in phase 1. Siderise acknowledges that its cavity barriers are incapable of being tested in a construction representative of rain screen cladding, except in specific tests. Yet it fails to advertise that fact clearly in its marketing materials. The failure by these manufacturers to acknowledge the seriousness of their behaviours, still less the consequences, renders any other assertions they make utterly hollow. The serious implications raised by the manufacturer's testing and promotion of the products used at Grenfell, which include the independence of testing and certification bodies, require a radical rethink of the current regulatory framework and testing regimes. The supposedly independent test and certification bodies acted in breach of the duties of impartiality and accuracy imposed on them by international standards, implemented in the UK by British standards. The failings and susceptibility to abuse of the large-scale fire testing regime are of the utmost importance, since this regime underlies the government's building safety programme, which prescribes the extent to which the combinations of products used on facades are safe or not. Critically, that programme currently allows on high-rise residential buildings so-called flame retardant FR, polyethylene cord cladding, albeit only in conjunction with mineral wool insulation, and also allows foam insulation, albeit only in conjunction with A2 cord composite cladding. These may, in fact, be dangerous combinations given the inherent flaws in large-scale testing and the way in which it's been abused to our knowledge from the very outset in 2005, namely just before the introduction of large-scale testing as an alternative route to compliance for both cladding and insulation as a system. These combinations certainly would not be permissible in new builds or overcladding now, since the amendment of the building regulations in 2018 to prohibit the use of any material below A2 in the facade. A feature which dominates the events leading to the use of products at Grenfell and therefore cannot be ignored is the role of culture and competence within both manufacturers and independent test or certification bodies. This issue is yet more important than the often asked question whether regulations should be changed from permitting performance-based design to requiring only prescriptive design. Both prescriptive and performance-based design require great competence in the designer. It should be remembered that insofar as the Grenfell designers considered routes to compliance at all, they all considered that the prescriptive route was being followed, and yet that still did not result in compliance. Perhaps the most sinister aspect of the events leading to the product selection at Grenfell is the manner in which the manufacturers well understood the statutory regulation and guidance and sought to circumvent it by clever marketing. So, for example, the manufacturers Kingspan, Celotex, and Arconic understood the importance of and misconceptions about Class 0 classification in the UK and went out of their way to advertise their products as having Class 0, even though, in fact, neither the Kingspan K15 or Celotex RS5000 and TB4000 insulation, nor the PE55 cladding panel used at Grenfell, in fact had Class 0 classification. What is more, Class 0 was of no relevance whatsoever to insulation, since the classification is only required under the linear route for the surface of the cladding panel, which was required to be Class 0, whereas the insulation was required to be of limited combustibility throughout. The manufacturers regarded so-called independent certifications, such as British Board of Agrément certificates known as BBA certificates, or Local Authority Building Control, LABC certificates, as mere marketing tools. And as a result, those manufacturers were anything but candid in their dealings with these bodies. Arconic, Kingspan, and Celotex well understood that the building control officer was the only obstacle to getting their products onto high-rise buildings, despite the use of such products over 18 metres being a breach of the building regulations and ADB if the linear route was being followed. The means to circumvent building control officers was by satisfying them with a BBA or LABC certificate. Yet worse, these manufacturers and their trade associations appear to have lobbied institutions such as the National House Building Council and the Building Control Alliance, which give guidance to industry, and in particular the building control sector. This enabled the manufacturers to, in effect, rewrite the guidance provided by Approved Document B, since they persuaded those institutions to produce guidance notably BCA's Technical Guidance Note 18, first issued June 2014, and NHBC's July 2016 Guidance on the Acceptability of Combustible Materials in Common Wall Constructions, including ACM on high-rise buildings. Both these pieces of guidance in some respects contravened both the building regulations and the guidance contained in ADB. By way of brief scene setting of the products used in the facade at Grenfell, first, the various forms of insulation, cladding panel and cavity barriers were uniformly unsuitable for use on a high-rise building. This despite the fact that the certificates and marketing materials suggested they were fit for such use. Second, neither the insulation nor cladding panel were of limited combustibility, as the insulation undoubtedly should have been, and we submit the panel should also have been, given the route to compliance with building regulations being followed was the so-called linear route under ADB. Third, there were no valid tests in place justifying the use of any of the insulation products nor the cladding panel over 18 metres, and the other tests on which BBA LABC certificates were based were either not genuinely carried out or not at all. Starting with the insulation, both the insulation manufacturers, Kingspan and Celotex, had carried out large-scale testing, known as BS 8414 testing, in a manner both they and those carrying out the tests should have known to be improper, by either concealing components designed to facilitate a pass and or using materials which were not as described in the test reports. The events which led to foam insulations being used on Grenfell began in May 2005, when Kingspan carried out a BS 8414 test shortly before the ADB consultation in July. By the July consultation, government proposed to introduce the BS 8414 test as an alternative means to compliance, not only for the cladding panel, which is already allowed as an alternative to the compliance, to ADB compliance, but also for insulation, which had since 1992 been unequivocally required to be of limited combustibility. Kingspan in 2005 set the precedent that its combustible polyurethane insulation K15 could pass a BS 8414 test for overcladding and masonry construction. This test was not genuine, as I will explain. This was the only BS 8414 test suggesting foam insulation could be used over 18 metres for some 7 years until 2012, when another insulation manufacturer, Extratherm, passed the test, a test result which was also withdrawn following the fire at Grenfell. Kingspan's BS 84141 2005 test is the only test which had any relevance to the Grenfell Tower as at the date of first supply of Kingspan to Grenfell in May 2015. Kingspan's later apparently successful test of K15 in July 2014 was of no relevance to Grenfell, as it was under the BS 84142 test for cladding on a steel frame. It is not a defence for Kingspan to say, as it does by its written submissions, that it was not aware of the use of K15 on Grenfell until after the fire. Kingspan has gone out of its way since 2005 to ensure that the 2005 BS 84141 test had the broadest possible application, even though it's clear that BS 8414 is a system-specific test and by definition not of general application. Kingspan even sought to extend the application of its BS 84141 test for masonry buildings to steel-framed buildings, despite the fact of the different BS 84142 test for that. The fact that Kingspan did not specifically target Grenfell as a project is irrelevant. All Kingspan's actions over a prolonged period were designed to give the impression that the 2005 test proved K15 could be safely used over 18 metres, regardless of whether the construction was the same or even close to that tested. As to the relatively small amount of K15 on Grenfell, we await the expert's opinion on the extent to which K15 would have assisted rapid flame spread. Given much was on the columns, it may be highly significant given the way columns acted as chimneys, fueled, as Dr. Lane reported in phase 1, by the insulation within them. Furthermore, in a general sense, Kingspan's actions were seminally causative, in that it was at this time regarded as the industry leader, and it set the precedent that combustible insulation could genuinely pass a BS 8414 test and so be used over 18 metres. The inquiry should ignore Kingspan's claims that it has successfully replicated the 2005 test in 2019, thereby demonstrating that K15 could have passed even without the significant distortion of the 2005 test which occurred. Mr. Pargeter of Kingspan observes that the test conducted in June 2019 was not a perfect replica of the 2005 test. And indeed, how could it be, since Kingspan employees struggled some years after the test to identify precisely what components had been used in the 2005 test. Furthermore, as the schedule of major changes Mr. Pargeter exhibits to his third statement shows, the K15 product has undergone so many changes that it isn't the same formula at all as that which was used in 2005. Kingspan's willingness to suggest that a test many years later on what is in effect a completely different product demonstrates the 2005 test could have been successful undermines their credibility. More bizarrely still, and as we heard from Mr. Millett this morning, we learnt yesterday that Kingspan has only formally written to fire engineers on the 23rd of October 2020, some 4 days after receipt of the written opening submissions, to withdraw the 2005 test. We had suggested in our submissions that Kingspan had in fact withdrawn the test in 2019 because Mr. Pargeter's second statement at paragraph 22.4 suggested as much, but it now transpires that the test had not formally been withdrawn. The 2005 test should, as Kingspan accepts, have been withdrawn in 2006 and frankly not relied upon in the first place given the circumstances of its execution. This very belated withdrawal is not to Kingspan's credit. Following the 2005 test, Celotex in May 2014 picked up the baton from Kingspan using an essentially copycat method of passing the test on its RS5000 PIR insulation, only this time using a BS 84142 test for cladding on a steel frame, not masonry. Although this test was irrelevant to Grenfell, by November 2014, Celotex had identified Grenfell as a must-win bid and made contact with Harley to secure the use of RS5000 on the project. As for the cladding panel, Arconic had carried out, also in 2005, testing under the harmonised standard EN 135011 at a French government test house, including what is known as EN 13823 or the single burning item test, which, although smaller scale than the BS 8414 test, nevertheless involves the construction of a mocked-up rig. Based on Arconic's own assessment of the position, it appears an artificial construction of the rig was used to obtain a B classification for the rivet version of Reynabond PE55. The cassette version tested at the same time was given an E classification as the test had to be stopped. Although the cassette version of PE55 was the one used at Grenfell, nevertheless, Arconic's artificial test of the riveted panel played a critical role in the story which led to Grenfell, as it was this test alone which Arconic chose to share with the BBA for the purpose of obtaining its BBA certificate, which gave a B classification to Reynabond PE55. The certificate on its face appeared to apply to both riveted and cassette versions, and the first page featured a photo of a high-rise building supplied to BBA by Arconic. Each of these manufacturers fully appreciated the inherent flammability of their products and its unsuitability for use over 18 metres, as illustrated by events. The only reason to manipulate a test by secret modifications to the rig and/or by using materials or products which are unrepresentative of ordinary construction products is that you know the product will not pass unless you do. Celotex had acknowledged internally on November 2013, even before embarking on its BS8414 test, that on one view, its product realistically shouldn't be used behind most cladding panels because in the event of a fire, it would burn. Turning briefly to the relevant regulatory regime, the issues within Module 2 require us to consider two relevant regimes. First, the regime governing the supply of products to the market by manufacturers and distributors. Second, the regime governing specifiers and contractors in selecting products. The regime governing manufacturers and distributors is contained in the Construction Products Regulation 2013, which implements the European Council directive known as the Construction Products Regulation 2011. That regulation requires that where there is a European harmonised standard in existence for a product, then it must be CE marked and a declaration of performance must be drawn up for it. It is an offence not to draw up a declaration of performance or to fail to bring a product into conformity with that declaration if manufacturers have reason to believe their product is not in conformity. If, however, there is no European standard for the product, but instead there is a set of guidelines published by the European Organisation for Technical Approvals, then the manufacturer may apply for a European technical appraisal under those guidelines, but is not compelled to do so. CE marking is beneficial to manufacturers as it's like a passport which makes the products easily marketable within Europe, and it's beneficial to end users because the mark guarantees the product meets European safety standards and complies with EU legislation. The second regime governs the designers and contractors. All construction work is potentially subject to the Building Act 1984, which provides for the publication of building regulations. Those regulations provide that relevant building work must comply with the 5 functional requirements in Schedule 1 of the regulations. Those include, at B4, the requirement that the external walls shall adequately resist the spread of flame. Practical guidance as to how the functional requirements are to be achieved is contained in the approved documents with ADB relating to fire. The Building Act makes clear that compliance with the approved documents is not a complete defence to liability for non-compliance, and ADB makes clear that it's possible to justify compliance by means other than those contained in it. If ADB is followed, however, then it provides for 3 routes to compliance. First, the linear route in section 12.5 to 12.9, which at the time of Grenfell expressly required insulation to be limited combustibility, and by virtue of the health warning in 12.5, we submit that it also required that limited combustibility cord cladding be used with a class 0 external surface. There was a debate about whether the core of the cladding panel should be limited combustibility, although industry guidance in the form of BCA's Guidance Note 18, issued in June 2014, made clear that the linear route required the panel to be of limited combustibility. The second route was that the criteria within a document called BR 135 must be satisfied, which set parameters for the large-scale BS 8414 tests, principally in terms of maximum permissible temperature to be reached within a designated time. Third, a fire safety engineering approach. This was expressed to be targeted at a specific element of the design which was either problematic or a complex structure such as an airport terminal. Our regulations at the time of Grenfell therefore utilised a predominantly performance-based approach, telling designers what functionality was required rather than telling them how to achieve it, but also proffering a linear or prescriptive route. That performance versus prescriptive balance has shifted slightly with the 2018 amendment to the building regulations prohibiting products which are less than A2. It's important to note that ADB did not provide for compliance by means of a desktop study. This was introduced by the BCA Guidance Note 18 and was defined as the opinion of a suitably qualified fire specialist that the cladding system proposed would meet the criteria of BR 135. Importantly, Regulation 7 of the Building Regulations requires that products and materials are appropriate for the circumstances in which they are used. This is elaborated by Appendix A of ADB, which requires that the product must either be in accordance with the design shown by tests to be capable of meeting the performance required by a British or European standard, or have been assessed from test evidence by a UCAS accredited laboratory using appropriate standards or design guidance. That guidance was the extended application or EXAP rules implemented in the UK by British standards. The Fire Test Study Group also produced guidance on assessments of products in lieu of tests in June 2000. Both the EXAP and Fire Test Study Group guidance are clearly targeted at providing for the extrapolation of tests from one product to others within a family, as opposed to extending the results of an entire system test to another system. A means of extrapolating the large-scale test now exists in the form of BS 9414, but this did not exist at the time of Grenfell. This calls into question all desktop studies carried out. The sinister rewriting of the ADB guidance, which began with BCA's Guidance Note 18, introducing the concept of desktop studies, was inappropriate in that there was at the time no means of extrapolating the results of a BS 8414 system test. Furthermore, the July 2016 guidance went yet further and contravened both the requirements of the building regulations and of ADB by introducing the ability to use combinations of highly flammable material over 18 metres, ACM and foam insulations, in a defined wall build-up from inside to outside, but without the need even for a desktop. It is now clear that Kingspan was actively involved in the drafting of both pieces of guidance, as internal email exchanges show. Kingspan was, in its own words, slowly educating the NHBC and working with them to produce BCA Technical Guidance Note 18 that promotes BS 8414 and desktops. Turning to the BS 8414 testing regime, which underlay the alternative route in the ADB guidance and which underlies the government's building safety programme, it's instructive to consider its history. As at 2005, the consultation on ADB proposed the BS 8414 test as an alternative route to compliance for the insulation. This suggests we had forgotten what we knew, namely that combustible insulation poses a threat to life and needs to be of limited combustibility on taller buildings. Large-scale testing was initially suggested in 1988 by the first edition of BR 135 only for insulation, because at that point in time, combustible insulation was permitted by the then in force ADB 1985, provided it was encased in brick or block. The first edition of BR 135 recognised that even encased in brick or block, insulation provided a risk of progressive fire spread within the facade. By the time the first large-scale test, Fire Note 9, predecessor to BS 8414, was introduced, it was an alternative means of compliance for the cladding panel alone. That was because, by that time, the then in force ADB 1992 required insulation must, without exception, be limited combustibility over 18 metres. ADB 2006, however, introduced large-scale testing as an alternative means of compliance to the linear route for both cladding panel and insulation. As we know, the manufacturers were alive to this change and sought to exploit it. It's ironic that the large-scale test, first proposed in order to protect life by recognising the inherent risk in using combustible insulation at a time when its use was not prohibited, has become a vehicle for abusing the system and allowing combustible material back onto walls at height. As Dr. Lane will give a presentation next week on testing, I shall say only that which is necessary to explain Kingspan and Celotex's abuse of the BS 8414 tests. The large-scale test consists of a rig 6 metres high with a main wall and a side or wing wall. Both are mocked up with cladding panels, cavity barriers and insulation, with a crib containing the heat source in the main wall. The test lasts 60 minutes from ignition, with the heat source being extinguished after 30 minutes. The performance of the cladding system is judged by reference to the criteria in BR 135 governing maximum permissible temperatures allowable within prescribed times. These are measured at 2 sets of the thermocouples running horizontally across the rig. If these temperatures are exceeded, or importantly, the flames overtop the rig, then the test is a fail. However, as the BS 8414 tests themselves contain no pass or fail criteria, whilst the system tested and the time temperature data is recorded in a test report, the test can only be meaningfully interpreted by a classification report from the test house, which confirms whether or not the criteria in BR 135 have been met. A further problem with the BS 8414 tests, and indeed the smaller scale tests under BS EN 135011, is that products may be assisted to pass using fire retardants, which have the effect of delaying the time to ignition and reducing flame spread in a test. But that is not indicative of how the products will behave in a real fire. This practice of adding fire retardants is clear from papers Saint-Gobain has, including its Northborough research paper, which makes clear that this practice of including retardants is not only hazardous to health and the environment, but furthermore, it is done solely, and I quote, in order to pass unrealistic fire safety tests. This stark fact alone calls into question the viability of large-scale testing as a measure of fire safety. The use of retardants to pass smaller-scale tests also needs to be addressed. Both Kingspan and Celotex have used fire retardants. As Paul O'Brat explained to Celotex's management committee by his email of the 13th of August 2012, fire retardant is used in all Celotex products. He expressed concerns that if levels of retardants were lowered, he would have concerns about the fitness of purpose of the product. Kingspan have used fire retardant lacquer specifically to ensure K15 passed BS 476 parts 6 and 7, so the class 0 tests, as Mr. Pargeter admits by his third statement. The deficiencies in the BS 8414 methodology have been well ventilated, not least that it's not reflective of what Dr. Lane calls real-life conditions in a facade, namely test windows, vents and doors. That's paragraph 01.120 of her phase 1 report. Arup is also on record as saying that it is practically impossible to replicate the test construction on site. Turning to the principal manufacturer's testing of the Grenfell products, I start with Kingspan's 2005 BS 84141 test of K15, which, as I've said, was the only relevant test prior to supply to Grenfell in May 2015. This test was wholly invalid. The inquiry will need to establish precisely what materials were used in the 2005 test, because the BRE report is, as one of the Kingspan employees said, quite ambiguous in some of its descriptions. It is, however, finally clear from Kingspan's 23rd of October 2020 letter to BRE that a non-combustible cement fibre board was used as a cladding panel. And we know that the cavity barriers were of a steel and graphite construction not freely commercially available. These materials were unrepresentative of ordinary cladding construction, and particularly the cavity barriers were of phenomenal efficacy, preventing the flames from overtopping the rig as it appears they otherwise would have done. One of the BRE engineers who assisted at this test recorded a seemingly falsified, delayed set of timings in his notes as explained in our submissions. These made the test seem credible when otherwise it would have been apparent that the flames had reached 4 meters up the 6-meter rig after only 5 minutes of a 60-minute test, thereby demonstrating that the test would have failed but for the cavity barriers. The 2005 test was rendered irrelevant a year after it was carried out, since there was a huge change in K15 technology in 2006. The 2005 test was carried out using old technology, whereas subsequent tests were carried out using new technology. K15, after the technology change in 2006, was a completely different product with poor performance in fire, as both Kingspan observers and BRE, who carried out a test on new technology K15 in 2007, acknowledged. Kingspan's observer referred to the rig as a raging inferno, and BRE made so-called unofficial comments, making clear the problem was not a system failure, but that in fact the K15 product was fully involved in the fire and continued to burn after the heat source was extinguished. It is therefore disappointing that Kingspan's submissions at paragraph 46 characterise the 2007 test on new tech K15 as a system failure, contrary to what BRE told them at the time, as is recorded in Kingspan's own internal 2008 report of that test. Kingspan, in its written opening submissions, relies on a successful test in 2014 to make the case that new tech K15 could have passed the 2005 test. We now know that that test has been withdrawn, but this test was demonstrably irrelevant anyway, principally due to the fact that it was under BS 84142 for steel frames, not for overcladding masonry as the 2005 test was. It also used a different cladding panel, namely terracotta, and as Kingspan accept at paragraph 51 of their submissions, the 2014 test was in any event not reflective of the K15 product because it utilised a research and development version of K15. As I said, Kingspan finally withdrew the 2014 test formally by its letter 23rd October 2020. But nevertheless, Kingspan relies on the fact of retesting of K15 with the terracotta panel in April 2015 to suggest that the July 2014 terracotta test would have passed, even if it hadn't been a research and development version of K15. A comparison of the test reports, however, for the terracotta tests in July 2014 and April 2015 at paragraph 48B and 53 of Kingspan's submissions shows the tests were not like for like, in that the cladding panel used and the cavity barriers were different, and the cavity barriers fixed in a different method. Kingspan's reliance on the 2015 tests to justify the withdrawn 2014 tests therefore does not avail it. The position remains that there was no valid BS 84141 test of K15 at the time of first supply to Grenfell. That Kingspan and possibly BRE had concerns as to the circumstances of the K15 2005 test after it was carried out is evidenced by the fact that despite recognising they needed to obtain a classification report for the 2005 test, Kingspan failed to do this until 10 years after the test, by which time it was, as a matter of industry practice, obsolete, since as resolved by the Fire Test Study Group, tests expire after 5 years. Kingspan recognised internally that advertising K15 to have been certified for use above 18 metres was, in its own words, dodgy, given the lack of classification report. The other test results relied on by Kingspan were Class 0 results. Whilst these are wholly irrelevant to insulation, Kingspan recognised the importance of these in the UK market and wanted them recorded in the all-important BBA certificates. Kingspan's Mr. Pargeter accepted in his second witness statement that he knew from 2016 onwards K15 could not achieve Class 0, but it now seems from his third statement, paragraph 34B, that the 2012 Class 0 tests had been assisted to pass using fire retardant. As explained in our submissions, the 2012 tests were regarded by Kingspan as their best ever and not repeatable. That is little wonder if fire retardant had been used. Kingspan appears to have no relevant Class 0 results for K15 at the time, and it sought and obtained its first BBA certificate for K15 in October 2008. Given the product had changed in 2006, and that, as Kingspan accepts by paragraph 40 of its submissions, the tests on the foil facer only, as opposed to the whole product, were undertaken in 2007. Despite this practice of testing the foil facer only being described subsequently by its own employees variously as a bit of a cheat and complete spin, Kingspan simply says it should have informed BBA of this, but nevertheless continues to rely on these and the 2016 tests as justifying K15's Class 0 certification. That's paragraphs 40 to 42 of their opening. In fact, there were no relevant Class 0 tests which could justify the BBA certificates. Tests in December 2008 were carried out on research and development versions of K15. Tests in 2009 were invalidated by the subsequent major product changes Mr. Pargeter refers to. Given Kingspan had used fire retardant to pass the 2012 tests, the December 2013 BBA certificate in force at the first supply to Grenfell was also obtained on a false premise. As Kingspan acknowledges, its change control procedures were lacking. This made it practically impossible to be sure of the precise characteristics of the product at any one time. Kingspan had to draw up a declaration of performance due to there being a harmonised European standard in respect of its product. That prior to Grenfell, July 2013, attributed a Euroclass C1, CS1D0. One wonders how Kingspan could be certain of the accuracy of such a declaration, given the major changes in formulation of the product and its faces recorded in Mr. Pargeter's schedule. Kingspan's dealings with the BBA as certifying body reflect a complete lack of candour on Kingspan's part, as we've explained in our submissions, with Kingspan at pains to obtain a BBA certificate which, in its own words, would be as open and delimiting as possible by not confining the use of K15 to the construction used in the BS 8414 test. As BRE would themselves acknowledge by internal email from Mr. Baker to one of his colleagues, and I quote, "The market is starting to get very confused through clever marketing by Kingspan." Meanwhile, within Kingspan, the tone was triumphal when certifiers such as BBA and LABC produced inaccurate statements about K15, such as LABC's stating that K15 was of limited combustibility. Even by its opening, however, Kingspan insists that the wording used by LABC to that effect was not entirely clear. It wasn't unclear, it was simply wrong and indefensible. Kingspan's would-be competitors, Saint-Gobain, noted Kingspan's, quote, great focus on delivery of results, irrespective of the obstacles and setbacks. One of those obstacles was statutory compliance, which was swept away by a large amount of internal testing and external testing, which was, as one of Kingspan's employees would later say, necessary to justify our lie. Kingspan's opening is devoid of any mention of the highly irregular circumstances of the 2005 test, the absence for a decade of a classification report in respect of that test, nor the use of fire retardants in its Class 0 testing, albeit these matters are attested to a degree by witnesses, and there is ample documentary evidence. Kingspan instead characterises its actions and failings as mere historical shortcomings. Turning to Celotex, it at least recognises that the behaviours of its employees were unacceptable insofar as they procured the carrying out of the BS 84142 test in May 2014 in a wholly improper manner by using magnesium oxide board, which is used in furnaces, to fortify the cavity barriers at the levels of the rig, which were critical to satisfying the BR135 criteria. Celotex also went on to procure a misleading report from BRE, which, apart from one photo, namely figure 18, which Celotex had sought to remove, concealed the way in which the test had been distorted. The photo Celotex had sought to remove clearly shows the effect of the reinforced cavity barrier at the top of the rig. It stopped the flames dead in their tracks. Celotex also accepts that the understatement of lambda values was wrong. Celotex's position, however, is that albeit these actions were wrong, they were of no causative effect on the specification, supply, and use of RS5000 at Grenfell. Whilst, of course, Celotex's BS 84142 test of a Marley Eternit cement particle board and over a steel frame was of no relevance to the construction at Grenfell, and RS5000 should not have been specified, that doesn't detract from the fact that Celotex set out, very much as Kingspan did, to obtain a report with the broadest possible number of applications. Mr. Roper's research email in November 2013, at the outset before Celotex testing began, makes this clear. He said Celotex wanted to test the worst case scenario and then extend it by an assessment report which would broaden the scope of potential systems to which K15 was applicable. Roper also noted that Kingspan had achieved this by an LABC report stating K15 can, quotes, be used in a variety of systems. Celotex followed suit by also obtaining an LABC certificate using that exact wording which Celotex itself had suggested to LABC. Furthermore, Celotex obtained a desktop from Exova dated the 26th of May 2015, which purported to extend the test to brickwork, terracotta, A1, laminates, and aluminium sheeting cladding, albeit the report does not in fact conclude that PIR can safely be used with aluminium sheeting. On top of all this, Celotex specifically pursued Grenfell. Celotex's email exchange in November 2014 makes clear that Grenfell was Celotex's #1 must-win bid. It is therefore wrong for Celotex to suggest that its wrongful actions had no impact on the selection and use of RS5000 at Grenfell. We agree that Celotex did not give the assurances in writing relating to the use of RS5000 at Grenfell, which Ray Bailey initially claimed they did. There is, however, no evidence that Celotex advised the proposed construction at Grenfell was wholly different to that used. On the contrary, Mr. Room asked Mr. Ansell-Jones to send him drawings of Grenfell by his email of the 27th of August 2014, and it was Mr. Ansell-Jones's evidence that he recalls Mr. Room saying RS5000 could be used over 18 metres without qualification. Furthermore, we know from the email thread between Celotex's head of technical, Rob Warren, and Mr. Stern, dated the 2nd of April 2015, which I read out in our Module 1 opening, that when the distributors, SIG, asked what Celotex advised when discrepancies between the proposed construction and the construction in which RS 5000 had been tested arose, Mr. Warren gave, in his words, both Celotex's official view and his own view. The official view was that the classification report only related to the system tested. His own view was, and I quote, "Celotex do not try to second guess what may or may not be deemed suitable. And if RS 5000 is rejected, we take it on the chin. We have had conversations with NHBC and are aware we will generally struggle to be accepted at this time." He ends by noting the degree of confusion amongst building control surveyors. In other words, Celotex's approach was to offer its product, see if it was accepted, and not discourage its use, even in wholly different constructions to that in which RS 5000 had been tested. Given this, and Celotex's intention expressed from the outset of the RS 5000 project, that it should be used in the widest range of constructions possible, and their desire to ensure their product was used on Grenfell, it is not open to Celotex now to assert that their actions had no causative impact on the selection and use of RS 5000 at Grenfell. Not least their own marketing data, whilst making reference to the specific system tested, nevertheless also sought to give the product its broadest possible application. For example, the data sheet, which states RS 5000 is the first PR insulation board to successfully test to BS 84142, meets the criteria set out in BR 135 and is therefore acceptable for use in buildings about 18 metres in height. Celotex cannot hide from the fact that its intention was to mislead and to trade on specifiers' known lack of understanding. This data sheet, along with other material, was sent by Room to Anctil Jones on the 27th of August 2014. Anctil Jones forwarded it by his email 18th September 2014 to Neil Crawford during the exchange concerning cavity barriers. It cannot seriously be suggested that given Celotex's strategy explained by Warren, which I've just read out, that Celotex's actions had no effect on the selection of RS 5000. Furthermore, Celotex's subsequent carrying out in April 2018 of a similar BS 84142 test to that carried out in May 2014 does not prove that RS 5000 could legitimately have passed the test in 2014, even without the interventions. Since in addition to the differences between the two tests admitted by Celotex, there is also the fact of the changes in formulation of the product, principally the polyol change in one of its production lines in 2012. Like Kingspan and Arconic, Celotex understood the importance of being able to market RS 5000 as Class 0, and it did so despite the fact that after 2012, it had only achieved Class 0 on one of its two production lines. Celotex and quite possibly Saint-Gobain have serious questions to answer about how the culture, which is clearly prevalent within Celotex, was allowed to take hold and persist. Anyone within Celotex or Saint-Gobain who knew RS 5000 was identical to the FR 5000 product, which was not advertised as fit for use above 18 metres, knew or should have known that RS 5000 was inherently not fit for use above 18 metres, and ought to have questioned why a product not fit for use at height was now simply being rebranded to suggest it was, but without intending to improve the product from a fire safety perspective. In any event, it's clear that some within Celotex became aware of the deceptive manner in which the May 2014 test had been carried out as early as October 2014. Debbie Berger's annotations on a version of the test report at this time make that clear. Jonathan Room also sought to stop Celotex promoting RS 5000 on NHBC projects in June 2015, and yet the product was not withdrawn until a few days after the Grenfell fire. This suggests a widespread culture within Celotex of ignoring compliance, and as we point out in our submissions, there had at the outset of the Celotex testing programme been a conscious decision by Celotex's management committee, MAG, to in effect adopt the Kingspan route. Celotex's behaviour towards certifying bodies and test houses was as poor as Kingspan's. The overwhelming likelihood is that Phil Clark of BRE, author of the 2014 report and also involved in the 2005 test, assisted Celotex in understanding how to pass the test. But by November 2014, BRE was explaining to Celotex's Berger and Room that attitudes were changing towards combustible insulation, pointing out that people had, quotes, been burnt by K15 approvals in the past, and the focus of insulation companies on sales rather than life safety. This, however, did not prevent Celotex from continuing to press NHBC to accept RS 5000 in the face of initially strong opposition from NHBC, who were aware of at least some of the flaws in the 2014 test. Last but not least, Arconic. It appears to have realised in 2005 that its PE product had poor performance in fire. This was the only explanation for Arconic's manipulation of the single burning item test of the riveted PE panel to achieve a Class B. Arconic began formulating its strategy for the UK in 2006 at a meeting in Luton, when Arconic suggested the need for a BBA certificate was pressing in order to capture the public sector of the market, which accounted for 50% of the available market. It seems the fate of the UK was finally sealed at the Freiburg meeting in July 2011 between Messrs. Werle and Fröhlich of Arconic and Ritter of 3A Composites, who make a Leucobond. They all noted the new regulations required a Class B as the minimum in Europe, and that this would force PE out of the market, in their view, within the coming month. By 2013, Arconic had a clearly formulated marketing strategy of targeting architects and investors, together with main contractors and installers, pushing the aesthetics of the product onto architects through CPD. This was to be achieved with the assistance of 6 approved fabricators. The strategy appears to have succeeded, since by June 2014, Grenfell was on Arconic's list of projects in the pipeline, which Debbie French was confident of winning, to achieve Arconic's recently increased UK sales forecasts. As already explained, Arconic had obtained its BBA certificate on a false premise, namely that RB55PE could be considered Class 0. That certificate was shown to Harley in relation to Grenfell by Ms. French in April 2014. Arconic had procured its BBA certificate by only providing to BBA its BS 476 test reports for Rainabond FR, not for the PE product. That was because RB55PE had no Class 0 test results as at March 2007. Despite that being of great concern to its then UK sales manager, who considered the lack of Class 0 represents a misrepresentation to the market. Furthermore, as already explained, Arconic had also obtained its BBA certificate suggesting PE was Class B by not showing to BBA its Class E certificate for cassette panels, and yet, on its face, the certificate applied to both cassette and riveted product. Arconic will have been well aware that if it was forced to declare a Class E for the cassette version of RB55, when the riveted version scored Class B, this would call into question its B classification for the rivet. So it was. Arconic went out of its way not to share its Class E rating with customers. In March 2010, Werle said in an internal email thread that the fact that the cassette panel doesn't achieve a B was, quotes, very confidential. Guy Scheidecker observed that, quotes, it shouldn't even have been mentioned. When Mr. Wehrle was pressed on this within Arconic by Ms. Moises in July 2010, he said, and I quote, "It's hard to make a note about this because we are not clean." Once the market did become aware of this disparity between riveted and cassette PE, Arconic was challenged on how this could be the case. The disparity suggested, as we know was the case, that the rivet tests could not be quite genuine. Arconic was, from at latest 2009, monitoring cladding fires around the world. Bucharest in 2009, Mermoz and Tamwheel Tower in 2012, La Crosse Melbourne in 2014, Torch Tower in the Address in Dubai in 2015, King Fahd Centre in Riyadh in 2015. Arconic breathed an internal sigh of relief every time the fire did not involve PE55, but yet it knew that all composites react the same way. Mr. Wehrle had been warning Arconic of the dangers of PE for some time, and given their tracking of international fires, Arconic can hardly claim ignorance. Furthermore, this knowledge appears to have reached the highest levels within Arconic. In April 2015, Mr. Wehrle made clear to Diana Pereira, American president of Arconic Building and Construction, that PE was Euroclass C to E and, in his words, flammable, and as such could not be used above 8 to 10 metres, depending upon the country. This gives the lie to paragraph B1 of Arconic's submissions that Arconic could not be reasonably expected to be familiar with the regime in other jurisdictions. Demonstrably, Arconic was so aware. Eventually, Arconic gave the instruction to no longer use PE on projects in France in May 2016 by Mr. Flacon's emailed instruction. But this came too late, considering at the very latest the American parent's April 2015 knowledge of the product's unsuitability at height and Mr. Wehrle's June 2015 email to Mr. Marichez stating all projects must be urgently switched to FR. No warning was, however, given to Grenfell, or indeed to other customers. On the contrary, Arconic's letter to customers of December 2015 stated that both PR, PE and FR were class 0, which was untrue, albeit noting that the reactions to fire of the two products were different. This was hardly the warning that the information known to Arconic would have justified. In view of all this, it is not open to Arconic to say, as it does in its written opening, that its role was merely a purveyor of product and it was for others to judge the suitability of it. Arconic actively pursued Grenfell Tower and was only successful, given that it was a public sector project, due to Arconic's having a BBA certificate, which it had in turn only obtained in the terms which it did by failing to make proper disclosure of tests to BBA. To hear from Mr. Millett this morning that Arconic's witnesses domiciled outside the UK are threatening not to attend the inquiry is something which the bereaved and survivors will struggle to comprehend, given their need to understand Arconic's role in the disaster. It will reflect poorly not only on those Arconic employees as individuals, but also on Arconic as a global company, if those involved do not come to the inquiry to tell what they know. By way of concluding remarks, we express our concern that the manufacturers are in general not humbled by the Grenfell fire, and their behaviours are not altered by it. Celotex at least admits some past wrongdoing, but they all seek to blame others. It is deeply troubling that Kingspan, having instigated a new business in 2018, Kingspan Facades, by which Kingspan will provide a prescriptive list of components for its own BS8414 tested systems, working, it says, with a limited number of recommended suppliers. No one who has read the correspondence and test reports can be anything but horrified at the thought of Kingspan expanding its ability to attest products, which intention is made clear by paragraph 93 of Kingspan's opening. What is needed is firm and independent scrutiny of Kingspan and other manufacturers. Yet Kingspan is now trumpeting itself as a paragon of Hackett-motivated virtue, while simultaneously giving the impression that it will continue to exploit the BS 8414 testing route. As Mr. Pargeter's K15 update report, only 3 months after the Grenfell fire, indicates testing Kingspan, showing no remorse, was using its participation in the government's testing programme to enhance its own position. Pargeter said, "Test is anonymous, so a fire safety engineer won't be able to put it down as Kingspan. We will be looking at challenging the norms that are associated with non-combustible. We'll be changing the gap to 4 millimetres, and if we get a pass, it's a credible alternative. Danger that if we win the test and Celotex PAR will then put in the test as they perform similar. We are looking for the next development to keep up ahead of the game. Strategy, support BS 8414 tests, support the use of desktop studies." Kingspan's unrepentant arrogance is truly chilling. Bearing all this in mind, and in particular the degree to which independent certification and testing has also suffered from a lack of impartiality, accuracy, and competence, we invite the panel to give careful and continuing consideration to whether urgent recommendations must be made before the end of phase 2, including a recommendation that the government should urgently review the premise of its building safety programme. Whilst we recognise the risks and difficulties in making individual recommendations in circumstances where fundamental overhaul of the regulatory system and underlying testing regime is required and the Module 6 evidence is yet to be heard, we nevertheless invite the panel to be required to make such immediate recommendations as are necessary to secure public safety. Unless I may assist further, those are my submissions.
Well, thank you very much indeed, Ms. Barwise. That's very helpful and very thought-provoking. We'll take a short break now. We'll keep it down to 10 minutes and resume at 20 to 12. All right? Thank you very much. Well, I'm now going to invite Mr. Hockman to make an opening statement on behalf of Arconic. Here he comes. Good morning. Good morning, Mr. Hockman. Can you see me? Can you hear me?
Good morning, sir. I can see you and hear you. I hope you can see and hear me.
We can, thank you. And so it only remains really for me to invite you to address us on behalf of Arconic.
Thank you, sir, and good morning to your colleagues as well. Before I begin my prepared remarks, I'd like to deal with two things by way of preliminary, if I may. The first concerns the observations that Mr. Millett made during his opening address as to the attendance by certain individuals to give evidence to the inquiry. I'm sad to say that I had no notice that he was going to make those remarks, although I suspect that one or two others may have had such notice. And this is obviously not the moment to respond fully to what he said, but I do want to make a few observations in relation to that subject right at the outset. There are three individuals, as we understand it, not four, three individuals, only one of whom is still employed by the company we represent, who, having taken their own separate legal advice, have, to date at least, declined to attend to give oral evidence. So far as the company is concerned, which we represent, Mr. Millett unfortunately misstated its position by suggesting that it has failed to cooperate with the inquiry, something which I hope we would never do. As Mr. Millett himself made clear, the inquiry has been in contact, and we understand remains in contact, with the French government via the UK Foreign Office, in the hope of providing sufficient legal assurances to enable the company's current and former employees to give oral evidence to the inquiry without the risk of criminal prosecution. And whilst the company obviously can't control whether any witnesses testify, the company remains willing to do what it can to assist the inquiry in working with the French government. So those are the remarks that I wanted to make about that subject before I start. The second thing, if I may, which I would like to mention, is the question of timing. Obviously, and I make absolutely no complaint about this, far from it, but I'm starting my remarks, I think, roughly half an hour later than was originally intended. On a dry run last night, my prepared remarks took me just under 45 minutes to deliver. And so, sir, if it's acceptable to you, I will aim to finish, I think it's about 11:45 now, I will aim to finish by about 12:30 or 25 to 1. I'll do my best anyway. But as I say, I won't be able to finish precisely within the time originally allotted to me, and I hope that you and your colleagues will understand that. So at the outset of these oral submissions on behalf of the company, I do wish to reiterate once again, if I may, our profound sense of regret in relation to the Grenfell Tower fire and its terrible consequences. We renew our sympathies to all those affected, and we recognise the importance of this inquiry in providing a comprehensive account of the causes and consequences of the fire and a fair and objective evaluation of the responsibilities of those concerned. We continue to hope that those watching and hearing these oral submissions will understand that if the inquiry is to fulfil its remit, it must receive representations from all participants, such as the company we represent, and must give those representations careful consideration if it's to arrive at a true and just conclusion. Now, in these submissions, I'm going to cover 7 headings. the supply of ACM, the use of ACM at Grenfell Tower, the UK regulatory regime, testing, the BBA certificate, and some wider factors. So firstly, the supply of ACM. And I want to begin by discussing the company's approach to the supply of ACM PE and to try to meet head-on some of the serious criticisms which have been levelled against us. It's clear from the evidence to date that the arrangements for the supply of the ACM panels were made on the company's behalf by its UK representative, Deborah French. The objective features of these arrangements will, we anticipate, hardly be in dispute, including the fact that Ms. French made available a copy of the BBA certificate. There can be no doubt that the decision as to the choice of product and method of fabrication was a matter for others and not for her. In the event, we know that the information provided by the company as to methods of fabrication was unfortunately not consulted by those involved in the Grenfell Tower refurbishment project. As a result, there were numerous departures from the company's information as outlined a long time ago by Dr. Barbara Lane in her Phase 1 report at Section 8. On the tower itself, only 2/3 of the external surface comprised ACM PE, and of that, at least 50% was comprised of panels fabricated in a fashion which can only be described as unorthodox. Indeed, as pointed out by Mr. Hyatt, the ACM PE used on the columns and crown of the tower were fabricated in a way which was entirely peculiar to Grenfell Tower, and which could not possibly have been anticipated by the company in a construction project of any kind. In relation to the more orthodox 50%, even that was utilized within what I might call an irregular building construction. There were numerous departures from regulatory guidance, including matters such as the absence of cavity barriers around window openings and so on. These deficiencies were not something which the company could have been expected to anticipate. In their written opening statements to the inquiry, and indeed in the oral comments that you heard earlier this morning, core participants have suggested that the company's employees were or must have been aware that ACMP panels would contribute to the spread of fire. We submit, however, that the correct question is whether there was an awareness that the panels could so contribute if the products were used within a cladding system that was not compliant with regulations or otherwise fit for purpose, and if so, whether such awareness ought to be treated as a basis for criticism. And without foreshadowing the evidence which will be heard in Module 2, the following 4 broad propositions are, we submit, beyond dispute. Firstly, cladding systems came under increasing scrutiny because a number of fires had developed across the world involving such systems, even though the precise details of those systems were not known. However, it was also the case that the product was capable of being used safely, even for high-rise residential applications, if the appropriate cladding system was designed and adequate safety precautions were incorporated into the building works. For example, as Professor Torero pointed out in his Phase 1 report at page 88, in those cases he mentions where buildings had experienced large external fires, there were no significant injuries, let alone fatalities, given the wider construction features and fire protection systems involved in those buildings. And so it is important to recognize, and this, as I say, is my first point, that a product is not inherently dangerous nor unfit for sale merely because that product may be inappropriate for certain applications or may be unsafe if it is misused. Secondly, even if there was the potential for misuse of the product, that did not impose any duty on the supplier of the product. It was reasonable for a company to conclude that it could rely on building regulations in the markets into which it sold, as well as the judgment of the professionals to whom it sold the products, to ensure that the product was being used appropriately for particular applications. The same conclusion was drawn by other suppliers who continued to supply ACMPE, who would indeed have supplied it for use at Grenfell if the company had not done so. The point has been made previously that the company had a small UK market share with only one authorised sale agent. It must be the case, if one thinks about it, that a supplier of a product is reasonably entitled to proceed on the basis that those responsible for the use of the product will do so in a way that complies with any relevant regulatory regime. This must particularly be the case where, as in the supply of the product for Grenfell Tower, those responsible for the use of the product are persons such as architects and construction professionals whose work is subject to regulatory oversight by building control officials. A supplier of a product must also be reasonably entitled to proceed on the basis that an application of the regulatory regime in a particular jurisdiction will achieve a suitable outcome. The standards set by the relevant regulatory regimes are a matter for the lawmakers in each jurisdiction. Insofar as it may be suggested, as it has been, that there were deficiencies within the UK regime or with the way it was implemented by those involved in the refurbishment of Grenfell Tower, it cannot be reasonable, we say, to suggest that the company should have identified those deficiencies and should already have withdrawn ACMPE from the UK market. Insofar as the company is concerned, the UK regime was an overseas regime, and it regulated not the supply of the product, but the building and refurbishment work. The company was entitled to proceed on the basis that the UK regulatory regime would ensure that a suitable outcome would be achieved by those responsible for the building works. And moreover, as I shall emphasise, that regime would itself have prevented the Grenfell tragedy if only it had been properly complied with by those on whom the relevant duties lay. So that was my second broad observation. The third, which is briefer, is this, that the company did make clear, we say, via the BBA certificate, that the fire performance of a product cannot be judged in isolation, but must ultimately be assessed as one component of an overall wall assembly. And therefore it was both permissible and appropriate, and I shall have a lot more to say about this, for the company to rely in promoting its product on the Class 0 classification or certification. Fourthly, and with the benefit of hindsight, we now know, of course, that the product was misused at Grenfell Tower as one component of a unique refurbishment that tragically failed in so many ways to comply with applicable regulations. But that is a fact that neither the company nor perhaps other manufacturers of single component parts of a cladding system could have been expected to know at the time. And it's worth noting that at the time the product was sold for use as one component of Grenfell Tower, there was no awareness of any fires involving Rainabond PE that had resulted in any loss of life or significant injuries. So we say at the conclusion of this section of my submissions that it would not be correct, despite the allegations made by others, to criticise employees within the company on the basis that they were, as it has been suggested, seeking to exploit the UK marketplace. Now my next heading, the use of ACM at Grenfell Tower. The first and quite general point to make is that just as ACMPE panels were widely used both in this country and abroad, so was their physical nature widely known and understood. We annexed to our written submissions a paper summarising the evidence currently available that's to say at the time, as to industry knowledge of the characteristics of ACMPE prior to the Grenfell Tower fire. It's a remarkable feature of the evidence within Phase 2 that hardly any of the witnesses called to date were prepared to acknowledge an awareness of the combustible nature of the core of the panel, though some admitted to an awareness that the core was plastic, and some, but fewer, admitted that it was therefore combustible. The inquiry may take the view that those who profess ignorance of these matters do so with their own interest to protect. We know from the evidence of Professor Bisbee that the challenging nature of the core would have been widely known among those concerned with fire safety. And in Professor Bisbee's Phase 1 report at paragraph 431, he acknowledges that PE materials are known to be highly combustible, something which in his oral evidence on the 21st of November 2018 he confirmed. So a responsible specifier would have taken into account the combustible nature of ACMPE when selecting the combination of materials to use on the external facade. Moreover, the inquiry may take the view that irrespective of the precise state of knowledge of individual witnesses and of their subjective evidence on that point, there is a more fundamental consideration. Since no one concerned with the choice or use of ACMPE could have been unaware of the existence of the core, it would follow that anyone responsible for the choice or the use of it had the option to check the combustibility of the core, whether by asking the manufacturer directly, which the evidence shows to have occurred on other projects, or by some other means, such as looking at test results available on the websites of testing and regulatory bodies, etc. And none of those responsible for the refurbishment can escape their share of responsibility by claiming ignorance or lack of information. In the case of Ryder, the main contractor, whose written opening is particularly critical of the company whom we represent, their attention was expressly drawn to the issue by the email relating to the Lacanal moment. And even this did not suffice to induce them to ensure that the regulatory regime was complied with. It's also indisputable that alternative options were available, including not only non-combustible insulation, but significantly less combustible cladding panels, including those which were fire retardant, an option of which any reader of the BBA certificate would have been aware. For example, the company at that time offered ACM FR as well as, I think, ACM A2 products, both of which were more fire retardant. In respect of such options, it's worth noting that at the material time, the company was reducing the price difference between its ACM PE and ACM Alpha FR panels. The evidence has also shown that a zinc composite material with a fire retardant core had originally been specified for use at Grenfell Tower. The white alu-glaze infill panels were, we understand, also available in fire retardant form. Above all, of course, the market was wholly familiar with the concept of non-combustible insulation, the only kind previously used in high-rise applications. Those who ultimately selected ACMPE for use at Grenfell Tower cannot credibly claim to have been ignorant of the availability of more fire-retardant alternatives, particularly having originally specified one such alternative, only to change the specification later in order, at least in part, to save money. The inquiry may have been struck in the course of Module 1, we respectfully submit, by the growing body of evidence to the effect that quite simply no adequate thought was given in the design, fabrication and installation of the cladding system to compliance issues in relation to fire. Indeed, it seems that few, if any, of those involved even managed to read the BBA certificate, or if they did, managed to read beyond the first page. There was a reference by Mr. Ashton of Exova to further analysis of the cladding issue to be carried out at a later stage. But as everyone concerned was or should have been aware, that further analysis never took place, nor was there any other evaluation, least of all in the local authority building control function, of the fire safety implications of the chosen combination and configuration of the materials used. This, we would submit, must be the central and perhaps shocking conclusion for the inquiry to draw as it enters into its consideration of Phase 2, Module 2. I think I'm still on track in timing terms, and I turn to my next section, which is entitled The UK Regulatory Regime. That regime, as we all know, applies to the construction and refurbishment of a building, and accordingly will be relevant to those who are responsible for the building work. It does not apply to those who manufacture and supply materials chosen by those who are involved in the building work. The suitability of a particular building product necessarily depends on the context in which it's used, and it is those who design and carry out the construction and refurbishment work who will have knowledge of that context, and who can reasonably be expected to have a detailed knowledge of the regime itself, which it would not be reasonable to expect of a manufacturer in any jurisdiction, particularly in a foreign jurisdiction. The role of the company that we represent was essentially to supply a product which required fabrication before use in a particular construction context. The company made recommendations, it is true, as to how to fabricate the product if the rivet or cassette version were to be adopted, but it was for others to decide which method to adopt for the fabrication of the product, how to fit the fabricated product to the external surface of the tower, what other components to combine with it, and in every respect, how to carry out the refurbishment. And it was the responsibility of others to take appropriate steps to achieve compliance with Part B4 of the regulations. There appears to be a suggestion that the company intended that its products would achieve compliance within the UK by reference to what has been called the linear route. This suggestion, we say, is clearly untenable for a number of reasons. In the first place, the company was in no position to formulate objectives in relation to the UK regulatory regime in which it had no expertise. Secondly, however, it is self-evident that compliance with the linear route would not only require conformity with paragraph 12.6 of approved document B, relating to the external surfaces of walls, but also compliance with paragraph 12.7, relating to the requirement that any insulation product, etc., should be of limited combustibility, which, of course, the insulation used at Grenfell was not. The failure to follow the linear route by those whose duty it was to do so was, we submit, the root cause of the spread of the fire. And it is clear, therefore, that those who were responsible for the design and construction of Grenfell Tower failed adequately to analyse the regulatory regime and to determine how they were to comply with it. It was not within the company's knowledge that any particular UK entity or individual working on the Grenfell project was making compromised decisions in respect of the refurbishment or failing to comply with regulatory requirements. Consequently, the company was not in a position to determine if the state of the UK regime was such that continued sale of ACMPE was problematic, and it was entitled to rely on the fact and belief that its product would be used in a safe manner in accordance with statutory building controls. Although the refurbishment works incorporating the installation of a cladding system at Grenfell failed to achieve compliance, it cannot be inferred from this that any and all construction projects with cladding systems, including ACMP, would have failed in this respect. As Mr. Hyatt said on Tuesday of this week, day 34, at page 179, it is possible for cladding systems as a whole to be compliant, even when including combustible products. And it is therefore possible that a building incorporating ACMP, but designed to be in compliance with the regulatory regime and including all appropriate features, such as cavity barriers and non-combustible insulation, would have been in compliance. And there are two examples before us showing that it is possible for a building designed in compliance with the regime to be constructed. The first is at Taplow on the Chalcot estate, where the cladding system comprised Rainabond ACM PE cladding in rivet fabrication and with rockwool insulation. The fire did not spread across the outside of the building because of the overall cladding system used. The precise features in the cladding system and the construction of the building, most notably the fire breaks, limited the fire to a small area. Another relevant example is the fire in 2010 at Sudbury House, Wandsworth, I think a 24-storey tower clad in ACM PE, this time fabricated as cassette with mineral wool insulation, which CEP, who were involved in that construction, I think, have confirmed was contained, just like the fire at Taplow House. Before leaving the topic of the regulatory regime, let me add one further comment concerning the construction products regulations, because we have noted that the original suggestion in written openings that the company was in breach of the construction product regulations has now, as you will have seen, been abandoned, it being accepted that there was no relevant harmonized standard for the product. In other words, and this is a comment of perhaps wider significance, an allegation of wrongdoing, which had been made, an allegation of wrongdoing, turns out to be a case of a business making legitimate commercial choices. Now I want to say something about product testing, and I'm afraid this is going to be a little bit technical, but that's unavoidable. Let me first distinguish between testing with regard to the national class and testing under the system of EN classification. Testing under BS 476 parts 6 and 7, which can lead to an outcome of national class 0. Testing under 476 is testing in relation to the unfabricated sample of a product. That is the product that the company that we represent manufactures and supplies. It does not involve a test of the fire performance of a fabricated product, in other words, rivet or cassette or otherwise, a fabricated product incorporated into a particular wall assembly. And therefore, NC0, which can be the outcome of a 476 test, NC0 is a classification in relation to an unfabricated product, and a classification, moreover, in relation, as Mr. Hyatt carefully explained, into the surface of the unfabricated product. And therefore, it can, as shown by other BBA certificates evidenced by the inquiry, and again, this was confirmed by Mr. Hyatt, an NC0 classification can be achieved alongside various different EN classifications. Now, the EN classification, the European system, is a test of the panels, in particular EN 13823 is a test of the panels in a particular mocked up system. The system in which the panels are assembled may vary from one test to another, not just in terms of the method of fixing, whether rivet or cassette, but also in terms of the substrate used, the size of the cavity, the arrangement of the panels, and other things. So if, for example, an ENB classification is achieved, it shows that the product is capable of achieving ENB in a particular system when fabricated in a particular way. But given the nature of EN testing, a classification such as ENB does not mean, and it cannot be treated as, achievable in all circumstances. Indeed, because the EN 13823 test relates to the testing of a product fabricated in a particular way in a mocked up system, which may vary from one test to another, two or more EN classification reports can coexist in relation to the same product at the same time. And it follows from all of the above that the time to test the potential use of the product in a particular context must be at the point of system assembly and by applying one of the routes to compliance. Now, in this case, we know that in 2005 and again in 2011, panels of the ACM product, panels of the ACM PE product configured in a particular mocked-up system achieved ENB. That shows that the product was capable of achieving an ENB. And although subsequent EN testing involving the product, in which the particular mocked-up systems will have varied, and indeed the particular method of fabrication, although on that EN testing, ENB was not achieved, this is not inconsistent with the fact that in 2005 and 2011, ENB was achieved, and therefore that the product was capable of achieving that result. The variable was not the product, it was the system into which it was incorporated. And this point is, in fact, illustrated by the written openings of certain core participants, which have referred to variations in the width of the cavity between the cladding panels and any substrate. Whilst there's no scientific evidence as to what the effect of that difference would be, it's right to note that variations of this kind are inherent in a process whereby the tested system will vary from test to test. Indeed, the width of the cavity may be only one of the differences between the tested systems. The systems in which the panels are assembled may also vary in terms of matters such as the method of fixing and fabrication, the substrate used, the arrangement of the panels, etc. And the fact that these features may vary from one test to another is a feature of the EN testing process, What's important is that the CSTB, the recognized testing body in France, nonetheless confirmed and published on its website the relevant test results, including those showing that in a given system, an ENB result could be achieved, as well as others less favorable. And the inquiry has documentary evidence showing that a range of EN classifications was shared by the company, both internally and externally. Against that background, let me turn my fifth topic, I think it is, to the BBA certificate. And let me deal with that in as much detail as I need to. Insofar as behaviour in relation to fire is concerned, let me stress at the outset that the BBA certificate went no further than to certify as to the surface of an unfabricated product panel and contained a range of caveats as to the fire performance of a fabricated panel in a particular cladding system. The first page of the certificate, as you know, describes the panels as aluminium polyethylene composite. No two ways about that. Everybody reading the certificate, even the front page, would know that the core was polyethylene, and states that a panel may be regarded as having a class 0 surface. And it refers the reader to section 6. And in section 6, at section 6.1, we see that when a sample of a standard PE product was subjected to an EN test, it received a B classification and was therefore capable of achieving that classification. That did not mean, as I've tried to explain, that an ENB classification would be achievable in all circumstances and irrespective of the method of fabrication and other features of the cladding system. Section 6.2 of the certificate then deals separately with the testing of a fire retardant sample. Section 6.3 then states that both products, that is both FR and PE, may be regarded as having a class 0 surface in relation to approved document B. And then, crucially, section 6.5 states that for resistance to fire, the performance of a wall incorporating the product is not covered by the certificate, and that the performance of the wall incorporating the product can only be determined by further tests. And then the certificate at section 6.6 states that cavity barriers should be incorporated behind the cladding as required by national building regulations, and that particular attention should be paid to preventing the spread of fire within a building breaching the cladding system through windows and door openings. It follows that the BBA certificate is cautiously worded. The reference to class 0 is expressly related to the surface of the product, and the certificate as a whole limits itself to specific examples of the product. Moreover, clear advice is given that the fire resistance of a cladding system incorporating the product is not covered by the certificate, but must be subject to further testing. And as you know, and I'll mention this quite briefly, these limitations are consistent with guidance contained in approved document B, paragraph 16, which itself restates the importance of checking any reference to the surface spread of flame to make sure that it's suitable to the construction to be used, and emphasizes that small differences in detail, such as differences in the fixings, may significantly affect the rating. That's in approved document B itself. Now, the assertion in section 6.3 of the certificate that the product may be regarded as having a class 0 surface in relation to approved document B is obviously a reference to paragraph 12.6 of the guidance and diagram 40. And so the certificate was simply setting out that since the product was capable of achieving the requisite European class, it could be treated for the purpose of compliance with the guidance as achieving the requisite national class. We do acknowledge, as other core participants have stressed, that under European testing, some fabricated versions of the product failed to achieve a B classification. But for the reasons I've tried to set out, that was not inconsistent with the NC0 certification, being a certification relating to the surface of the product, which in a particular system and when fabricated in a particular way had been shown to be capable of achieving the B classification. And as I've mentioned already, we know that the BBA were willing to certify NC0 for products with an EN classification much lower than ENB. Let me add that the BBA certificate was issued following a lengthy period of wide-ranging discussions between the company and the BBA. And in the course of those discussions, it was agreed that the certificate would relate to the surface of the relevant ACM products, both PE and FR, rather than to a sample cladding system containing a number of different components, of which the ACM would have been but one. We know that from the evidence of Mr. Albon of the BBA. And it was made clear to the BBA in the course of these discussions that for the purpose of fixing the ACM panels, two possible methods could be employed, rivet and cassette, which were alternative methods of fabrication and fixing and did not affect the nature of the product itself. Since the certificate was to confirm that the external surface of the product could be treated as National Class 0 for the purpose of Diagram 40, this conclusion would have remained unchanged even if the BBA had been provided, for example, with information on the fire performance of the core material standing alone, or even with information as to the fire performance of the product when fabricated or fixed in a particular way, whether rivet or cassette, because, to repeat, the certificate was simply to confirm that the external surface of the product could be classified as National Class 0. And please remember that the company also had available to it at the time Class 0 results in respect of another product called RB33, which had thinner aluminium skins but a thicker PE core than RB55. That you can see from Dr. Lane's table of results, her Appendix E at page E3. And it was surely a legitimate inference that RB55 PE would achieve Class 0 if RB33 with a thicker core but thinner aluminium skins had done so. On the basis of all this, the BBA itself determined that it was appropriate to issue the certificate in the terms in which it was issued, and in particular that the product could be regarded as having a Class 0 surface. And I might add that we know that the BBA consulted various external bodies, including the CSTB, in order to check and confirm that it was justified in issuing the certificate in these terms. In the light of the express warning in section 6.5 of the certificate, no one could reasonably or justifiably assume that the performance of a wall incorporating the product, whether fabricated and fixed by rivet or cassette, would necessarily correspond with the test results provided. So for all these reasons, I'm afraid we do not accept that the categorization of the product as NC0 or the BBA certificate itself misled the UK market. And indeed, we say that since the certificate related to the reaction to fire of the surface and the potential spread of fire across that surface, the NC0 classification in the certificate would not have changed in the light of further fire performance information following the issue of the certificate, unless the fire performance of the surface were to have changed, which it did not. An EN test result relating to the fire performance of the product in a particular cladding system would demonstrate and demonstrate only that the product was, as part of that system, capable of achieving a particular EN result. And therefore further EN results would not have impacted upon the classification contained in the BBA certificate unless any such result demonstrated that the product itself was incapable of achieving that classification. So we say, with great respect, that the ENE result, emphasized elsewhere, in a system involving cassette fabrication, as for example at Sudbury, did not detract from the fact that the product was capable of achieving ENB in an appropriate system, and that therefore the NC0 classification remained appropriate. Now I'm on my final and relatively brief heading, and all I want to do at this stage is to remind the inquiry, if I may please, of a series of events which, although crucial in terms of the eventual and terrible outcome, were nonetheless events in which, on any view, the company which we represent had no involvement at all. The first of these events was the start of the fire in flat 16. The inquiry has dealt with this in its phase 1 report. Obviously, no responsibility can attach to the company for the start of the fire. The second point concerns the extent, if any, of the fire safety precautions available within flat 16 and the remainder of the tower, on which you have heard and will continue to hear evidence concerning deficiencies in such precautions. Among other obvious points are the absence of a sprinkler system or other means of extinguishing fire within the individual flats, including flat 16. The next point is the escape of fire into the cladding system, and this is important. There can be no doubt that if the escape of the fire had been prevented or even delayed sufficiently to enable firefighters to extinguish it within the flat, then the Grenfell tragedy would simply not have occurred. It should never be forgotten that on the evidence, a delay of an additional few minutes in the escape of the fire would have enabled the fire service to extinguish it while still in the flat, without any of the terrible consequences which followed. And indeed, the stay put policy was based on the assumption that this would occur. The inquiry in its phase 1 report found that the firefighters entered the kitchen of flat 16 only 5 minutes after the fire broke out. And in your phase 1 report, you found that it was the use of combustible materials surrounding the windows and the absence of cavity barriers manifestly required by the regulatory regime which prevented the containment of the fire within flat 16 for those vital few additional minutes. Next, I would like to make brief reference in this review of wider factors to the expert evidence that it was the combustible insulation which could well have been the first major component of the cladding system to ignite, and which therefore played a key role in precipitating the ignition of the ACM panels. The importance of the presence of the combustible insulation emerges clearly from the comparison that we have drawn with Taplow and with Sudbury, where ACM panels were utilized in conjunction with non-combustible insulation. And so I would respectfully remind the inquiry that it's already clear that the kind of tragedy which occurred at Grenfell could only have occurred as a result of a unique combination of factors, including the combination and configuration of the materials used in the refurbishment, the failure of compartmentation and of other internal systems, and the undue reliance, one has to say, on the stay put policy, among other factors. And just to remind you that we attempted to assist the inquiry as to the involvement and interaction of many of these factors in the schedule which we submitted as part of our written closing at the conclusion of phase 1. And so, in my very brief conclusion, we would invite the inquiry in due course to conclude that the principal cause of the Grenfell tragedy was the failure by those responsible for the refurbishment of the tower holistically to consider fire performance as mentioned above. And we will be urging the inquiry against that background not to criticize a single product manufacturer for continuing to sell a product which had been in widespread use for many years and which could properly have been used at height in the context of building works which achieved the necessary regulatory compliance. Thank you very much.
Thank you very much, Mr. Hockman. At this stage, I'm going to invite Mr. Orr to address us on behalf of Celotex. So can we see if Mr. Orr can be brought onto the screen, please?
Good afternoon, Mr. Chairman.
Good afternoon, Mr. Orr.
Can you see me?
I can see you.
Can you see me and hear me?
And can you see and hear me?
I can see and hear you, sir.
Good, thank you. Now, before you begin, I'm very conscious of the fact that we're running behind time, as indicated in the timetable which I think you were sent. So the question I want to ask you is this. It's just after 12:30 now. You've been allotted an hour, and I certainly don't want to cut you down at all. Would you prefer to, well, if you start now, I think I'm going to have to ask you to find a convenient moment around 1 o'clock, give or take, to break your statement. Another possibility, although I'm not pressing you on this by any means, is that we take an early lunch now and give you an uninterrupted hour starting at, let's say, 1:30. I know you weren't expecting to be asked that question, but do you have a preference?
Mr. Chairman, I'm really in your hands. If the panel would prefer me to deliver my statement in one go, I'd be content with that. But I do think I could start now and find a convenient moment around 1 o'clock.
All right, well, it is a bit early, isn't it, to have lunch? So should we do that? If you'd like to start now, and I'll leave it to you to find a convenient moment round about 1 o'clock at which you would be happy to break your statement when you get there.
I'm grateful, sir.
Right, thank you.
So, Mr. Chairman, panel members, can I start by thanking the inquiry for this opportunity to make an opening statement at the commencement of Module 2. And I wish at the outset, on behalf of Celotex, to reiterate its deepest sympathy to the bereaved families, survivors, and everyone affected by the tragic fire at Grenfell Tower. Celotex has, from the very start of this inquiry, endorsed the need to ascertain what caused the fire and ensure that no such tragedy occurs again. Celotex is and has throughout been committed to providing its full cooperation and assistance to the inquiry. It recognizes the urgent need to ensure that public confidence in the safety of high-rise residential buildings and in the construction industry as a whole is fully restored. The work of this inquiry is fundamental to achieving that objective. Celotex has provided the inquiry with a written opening submission for Module 2. That sets out its position on the Module 2 issues in full. It provides references to relevant documents and to the evidence of witnesses who gave evidence in Module 1. I understand that it is now available on the inquiry's website for those who may be interested in reading it. In this oral opening statement, I propose to highlight the following points. First, Celotex's role in the refurbishment of Grenfell Tower. Second, Celotex's investigations following the fire. Third, the building regulations at the time of the refurbishment. Fourth, the marketing and supply of the Celotex products that were used in the refurbishment. And finally, and fifthly, the testing and marketing of Arconic's Rainabond PE cladding panels. Turning then first to identify the nature of Celotex's role. Celotex is a manufacturer of polyisocyanurate insulation, known as PIR. Two of Celotex's products were used in the refurbishment at Grenfell Tower. First, a product known as RS5000. This was used as insulation in the rain screen cladding system. Second, a product known as TB4000 was, Celotex understands, used to fill gaps in the window surrounds at Grenfell Tower. PIR is widely used in the construction industry. Its high insulation value helps building designers and contractors to meet modern energy conservation requirements. PIR is an organic product, which in common with all organic products will combust under certain conditions. The combustible nature of PIR was or should have been known to construction professionals considering the use of Celotex insulation. The combustible nature of the product was clearly highlighted in Celotex's health and safety datasheet, to which readers of Celotex's website and of its product literature were directed. The building regulations in force at the time of the Grenfell Tower refurbishment permitted combustible insulation to be used in high-rise residential buildings. There were additional requirements that had to be met when using combustible insulation in a building over 18 meters. But provided those requirements were met, PIR was acceptable for use in such buildings. The construction or refurbishment of a building over 18 meters involves a number of construction industry professionals from a variety of disciplines. They are responsible for ensuring that the building works comply with building regulations. That responsibility does not and cannot realistically fall on the manufacturer of an individual product, such as Celotex. That indeed was the position in respect of Grenfell Tower. Celotex was not part of the design or construction team on the Grenfell Tower refurbishment. Celotex did not design or construct the rain screen cladding system at Grenfell Tower. Its sole role was as the manufacturer of insulation, which was supplied through third-party distributors for the refurbishment. The distinction between a building designer and contractor on the one hand and a product manufacturer on the other is fundamental and we respectfully suggest needs to be borne in mind. Can I turn then to Celotex's investigations following the fire? None of the key Celotex personnel involved in the testing, certification, and marketing of the Celotex products used at Grenfell Tower remain employed by Celotex. Mr. O'Sullivan, Celotex's current managing director, joined Celotex on the 1st of May 2016 after the Celotex products used in the refurbishment were supplied. In the immediate aftermath of the Grenfell Tower fire, and in view of the focus on the role played by the rain screen cladding system on the tower, Celotex suspended the sale of RS5000 pending further clarity and set about ascertaining the relevant facts concerning the supply of that product for the refurbishment. This work was directed by Mr. O'Sullivan with the assistance of Celotex's lawyers, Linklaters. In the course of this work, certain matters came to light concerning the testing, certification, and marketing of Celotex's products, which were previously unknown to Celotex's current management. This included issues concerning the testing of RS5000 prior to its launch in August 2014, and the declaration of lambda values, which are a measure of insulating capacity for certain Celotex products. Once established, these matters were promptly announced by notices on Celotex's website and reported to the relevant authorities, including testing and certification bodies, the Ministry of Housing, Communities and Local Government, Trading Standards, and the Metropolitan Police. And in addition, Celotex made a full report of these matters to the inquiry. Celotex also instructed Linklaters to undertake a comprehensive review of all relevant documentation and other available evidence to ascertain as fully as possible the circumstances in which RS5000 was tested, launched, and marketed. The results of that review were set out in a summary paper which Celotex provided to the inquiry in September 2018, together with a witness statement from Mr. O'Sullivan. In his witness statement, Mr. O'Sullivan gives first-hand evidence of relevant events after he joined Celotex and an account of other relevant matters discerned from Celotex's documents. Now, following the emergence of the matters I have mentioned, Celotex was concerned to establish whether they gave rise to any safety issues. It conducted extensive due diligence in relation to the testing of its products, and it commissioned additional fire safety testing of both its 4,000 and 5,000 ranges of insulation. That testing confirmed that those products achieved the classifications that they were stated to have at the time of the Grenfell Tower refurbishment. Celotex recognizes that the matters which emerged during its investigations involved inappropriate and unacceptable conduct on the part of a number of employees. This was of real concern to Celotex's current management. Some of the employees involved had already left the company. Those who remained were the subject of disciplinary proceedings. 6 employees resigned between December 2017 and March 2018. So, panel members, Celotex has sought to learn from this experience. It has taken concerted steps to ensure that no such situation occurs again. Those steps include recruiting new technical and operational management, designing and implementing changes and improvements to Lambda and other testing processes, designing new quality assurance systems with the assistance of a new quality assurance manager, and reviewing and improving training procedures. Celotex recognizes that this is an ongoing process. It is committed to continuous improvement. Celotex has given careful consideration to whether the matters which emerged following the Grenfell Tower fire concerning the testing, certification and marketing of its products had any impact on the specification and use of those products at Grenfell Tower. On the evidence, there is, we submit, no basis for believing that those matters did have any impact on the specification and use of the products at Grenfell Tower. This point is addressed in Celotex's written opening submission. I will also deal with it in this oral opening statement. I need, though, first to outline the relevant building regulations that were in force at the time of the Grenfell Tower refurbishment. At the time of that refurbishment, the building regulations permitted the use of combustible insulation in buildings over 18 meters in height. The statutory guidance set out in Volume 2 of Approved Document B, known as ADB2, provided 4 routes to compliance for a rain screen cladding system. First, the linear route, which involved compliance with the requirements of sections 12.6 to 12.9 of ADB2. Second, testing the complete cladding system in accordance with British Standard 8414 in order to demonstrate that the system met the performance criteria given in the report produced by the Building Research Establishment on the fire performance of cladding systems, known as BR135. Third, obtaining a desktop study from a suitably qualified fire specialist, confirming that the complete cladding system would meet the performance criteria given in BR135 if it was tested to BS8414. And fourth, carrying out a holistic fire engineering study taking into account the adequacy of fire prevention measures in the building and other factors affecting fire spread to demonstrate that the cladding system would adequately resist the spread of fire over the walls. Now, the linear route to compliance was only available if each of the individual components in the cladding system met specified standards of fire performance. In particular, under the linear route, the insulation needed to be of limited combustibility. If combustible insulation like PIR was being used, the linear route was not available. One of the other three routes to compliance would then need to be followed. That is clear from ADB2. And it would be helpful if we could have on the screen at this stage the particular page from ADB2. The reference for that is CLG 50224 at page 96. Now,
sorry, just a moment. It's coming up, I think.
Now, what this, so the relevant provision here is section 12.7 of ADB2. And what this provision makes clear is that any insulation product used in the external...
we haven't got it yet. Would you like to wait until we get it up? Ah, it's just come up.
Apologies, Mr. Chairman. It was up on my screen.
Ah, well, it's up on ours as well now. Yes, on you go.
So 12.7, section 12.7 is what we should be looking at. And what that makes clear is that any insulation product used in the external wall construction of a building over 18 meters had to be of limited combustibility if one was following the linear route to compliance. Now, PIR was clearly not of limited combustibility. That was apparent from the definition of limited combustibility in Appendix A of ADB2, to which section 12.7 refers. In general terms, a product was only of limited combustibility if it was non-combustible. For example, if it was a totally inorganic material such as concrete, or was classified as Class A1 or Class A2 under European standards. That did not include PIR. Industry guidance available at the time of the refurbishment emphasized that PIR did not meet the requirements of section 12.7 of ADB2. For example, Technical Guidance Note 18, issued by the Building Control Alliance, stated that thermosetting insulants, which include PIR, do not meet the limited combustibility requirements of ADB2 and so should not be accepted as meeting ADB2 paragraph 12.7. That's specifically referred to in Celotex's written opening submission at paragraph 35, subparagraph 4. It therefore was, or should have been clear to any designer or contractor that if they were following the linear route, PIR could not be used. Indeed, Mr. Hyatt, the inquiry's architectural expert, confirmed in his evidence earlier this week that any reasonably competent architect would have known that PIR products were not compliant with the linear route. If therefore PIR was to be used at Grenfell Tower, any designer or contractor should have known that one of the other routes to compliance had to be followed. Each of those routes to compliance required the fire performance of the cladding system as a whole to be considered. That brings me to the second of the four routes I mentioned. This involved testing the complete cladding system to BS 8414. Now that is a substantial undertaking requiring construction of the system on a full-scale test rig, which is then subjected to a fire load simulating a fire escaping from a window. There are only a small number of testing houses in the UK with the capability to conduct such tests. At the time of the Grenfell Tower refurbishment, it was standard practice to widen the scope of application of a BS 8414 test by way of a field of application report or a desktop study. These studies enable building designers and contractors to extrapolate the results of a BS 8414 test of a particular cladding system to determine whether a system containing different components would, if tested, meet the performance criteria under BR 135. Now, BSR Team 1 appears to suggest in its opening submission that desktop studies were not a permitted route to compliance. That, we submit, is wrong. All 4 of the routes to compliance I have identified were well established by the time that insulation and cladding products were purchased for the Grenfell Tower refurbishment. They were identified in industry guidance available at the time, including the technical guidance note issued by the Building Control Alliance to which I have referred. Furthermore, Mr. Hyatt has confirmed in both his expert report and his oral evidence this week that all 4 routes to compliance, including desktop studies, were available at the time of the Grenfell Tower refurbishment. Now, during Module 1, there was much discussion about Class 0. This is a national fire performance classification for individual construction products. At the time of the Grenfell Tower refurbishment, Class 0 was relevant to the specification and use of cladding products on the external surface of an exterior wall under the linear route to compliance. That appears from section 12.6 of ADB2, which required the external surfaces of walls to be classified as Class 0, which, as I've said, is a national classification, or alternatively Class B or better under European standards. It is clear from section 12.6 that these classifications, that is Class 0 or alternatively Class B or better, applied only to the external surface of the wall. They did not apply to the insulation that was installed within a cladding system behind the exterior cladding panels. Under the linear route to compliance, insulation in the cladding system was required to be of limited combustibility, as I've explained. ADB2 made clear that Class 0 and limited combustibility were different concepts and were not interchangeable. Each of these terms was separately identified in ADB2. Class 0 was determined by specific fire tests under British Standard 476 Part 6 and 7, whereas limited combustibility was defined, as I've said, in Appendix A of ADB2. The various routes to compliance I have mentioned should have been known to the construction professionals involved in the refurbishment of Grenfell Tower. The relevant provisions of the building regulations and ADB2 were well established, having been in force since 2006. They were well publicized in industry guidance available at the time, including the technical guidance note I have mentioned. However, the evidence given in Module 1 now shows that the construction professionals involved in the Grenfell Tower refurbishment were unaware of, disregarded, or otherwise failed to follow the requirements of ADB2 when designing and constructing the cladding system at Grenfell Tower. They gave no proper consideration to which, if any, potential route to compliance they were following. Importantly, they had no regard to the fact that the insulation and other components of the cladding system were combustible, and they did not consider what impact that had on compliance of the cladding system with building regulations. Nor did they undertake any assessment of the fire performance of the cladding system they were proposing to install, whether by way of a desktop study or otherwise, despite the linear route to compliance not being available. These failings on the part of the designers, contractors, and fire safety consultants were fundamental, and they should have been identified by RBKC Building Control. However, that did not happen. None of these matters was Celotex's responsibility. So I'm now moving to a new topic, the supply of the Celotex products used in the refurbishment. So that may be a convenient moment.
Yes, well, if that's convenient to you, I suggest we stop there and we'll resume at 2 o'clock, if that's all right.
Thank you.
And we'll look forward to seeing you then.
Thank you.
Good. Thank you very much. 2 o'clock then, please.